We
All
good?
right, we're now recording.
Great. Thank you everyone for joining the DFR's Public Adjuster Licensing First RAC meeting. I appreciate all of you dialing in today to share your input. We'll start by taking roll call and a brief introduction for everyone. I'll begin, and then we'll move to the other DFR folks and then to the external RAC participants. So my name is Scott Klemke. I am a policy analyst. I work for the DFR in the policy division. And I welcome you here today. Let's go next with Jesse, if you don't mind.
Yes, good afternoon. My name is Jesse O'Brien. I'm the manager of the policy section with the division. And sorry, I'm not on camera. I'm a little under the weather today, but I'm glad to see that folks were able to join.
Eric?
Good afternoon. My name is Eric Cutler. I'm the Insurance Licensing and Retaliatory Tax Manager here at DFR.
Thank you. Jason?
Good afternoon, everyone. My name is Jason Flanagan. I am the Senior Compliance Specialist and run day-to-day operations of insurance licensing for the state of Oregon.
Karen?
Good afternoon. I am Karen Winkle, and I'm the rules coordinator for the division. I will be filing these set of rules.
Thank you. I don't see any other DFR reps, so why don't we move on to the external folks. Michael Richmond Crum.
Hi there, I'm Mike Richmond Crum. I am Director of Personal Lines and Counsel with the American Property Casualty Insurance Association.
Thank you. How about Brandon?
Hey there, Brandon Vick, National Association of Mutual Insurance Companies. I'm the RVP for the Northwest.
Excellent. Thank you. Scott?
Hi, Scott Zimmerman. I am the Property Claims Manager at Mutual of Enumclaw Insurance.
Chris?
I'm Chris Coughlin. I'm the Policy Director with Oregon Consumer Justice, and one of our policy analysts, Angela Donnelly, is also going to be joining the call today.
Sorry, can you repeat that other name?
Angela Donnelly.
Jeff, are you on?
I am on, thank you. Jeff Gould, past president and current legislative chair for the National Association of Public Insurance Adjusters, and thank you for the opportunity to participate.
Excellent. I'm glad you're here. I just saw a pop-up message from Tim Mullen having difficulties dialing in. I guess we'll wait to see if he is able to crack the code. Lori Wolf, are you on? How about Sandra Moriarty? Okay, anyone I missed? Very well.
This is Tricia Goldsmith. I'm the Consumer Advocacy Manager with DFR. I put it in the chat too, but I've joined.
Oh, thank you, Tricia. Appreciate it.
Yep.
Okay, great. Again, I appreciate everyone joining us today. Again, this is for public adjuster licensing, something new for Oregon. Couple of housekeeping items. If you could stay muted until you speak, that would be helpful. It makes a little more sense if we raise our hands to avoid talking over each other. So if you could use the raise hand function in the Teams meeting, that would be helpful as well. And as always, be respectful of others' opinions, and we encourage active engagement and participation. So with that, we'll go ahead and get started. Jason here, who's in charge of licensing, will give us kind of an overview and background of what got us here to this point. Jason?
Good afternoon, everyone. So for the longest time, Oregon statute, it doesn't distinguish between an independent adjuster, who's one who handles claims on behalf of the insurer, and a public adjuster, who is someone that's hired by the insured to negotiate with the independent adjuster. We've just issued an adjuster license, and so that's been sort of it. It doesn't provide us with the necessary tools to kind of appropriately regulate public adjusters, because primarily we've only licensed independent adjusters, and that's all that's really the adjuster classes that are listed in statute. I originally started with this process, suggesting it as a legislative concept, and it was determined that it was more better addressed via rulemaking, which is fine. The reason for this is I think that most states differentiate between a public adjuster and an independent adjuster. I think that's something that Oregon should do as well, for a variety of reasons. For one, it gives us some regulatory tools in the event of a consumer complaint. Right now, with public adjusters, I have no doubt that there are public adjusters operating in Oregon that are not licensed because the statute doesn't specifically say that they need to be. I think we need to clean that up. Additionally, when we have applications for people that are public adjusters as non-residents, we've been using paper applications for these because our business rules with NIPR don't allow a public adjuster us to issue an independent adjuster license to a public adjuster from another state. So this will actually eliminate the majority of remaining paper applications for the state of Oregon. Because right now with the paper applications, they get sent to fiscal, who takes the payment and then redacts the credit card information, sends them up to licensing. And then we process the applications after we have to manually build them into state-based systems. So this will be a much improved, a work improvement. Sorry, I'm trying to trip over the words. Most states either license public adjusters only and not independent adjusters, or independent adjusters only and not public adjusters. And then there are a handful that license both. I personally believe it's only a matter of time until all of these states are going to offer both a public adjuster license and an independent adjuster license, just to make all states largely uniform. Regularly at national conventions, the biggest discussion is uniformity amongst the states, particularly for rules and regulations that impact adjusters. So that's the other primary reason to move forward with this process. And I think that sort of explains where we're coming from with this. And I don't know, Scott, was that kind of what you had in mind?
Exactly. Thank you. That's a very good summary. Before we move on, I see we had a couple new folks join. Sandra, could you introduce yourself and who you represent?
Sorry, had to find that. Hi, I'm Sandra Moriarty. I am here with United Policyholders Consumer Advocacy Group, and nice to be here.
Thank you. I saw at one point Lori Wolf joined. Are you still on, Lori?
Good afternoon. It's Lori Wolf. I am only on by phone. I was having problems getting on, but I did dial in. So I'm here with NIPR. Thank you.
Great. Thanks for being here. Okay, with that, let's go ahead. I will warn you, this is a little bit lengthy. Hopefully you had a chance to review the materials that I sent out beforehand. In general, this is a set of rules crafted by the DFR, primarily driven by Jason, and utilizing the NAIC Model Act as a, I guess, as a skeleton, and that's really the basis for what we have. We've got a rather lengthy text to go through. I apologize if this gets a little boring, but for the record, I'll go ahead and read each one of these rules individually. And after certain chunks, we'll go ahead and open it up to group discussion, if that works for everyone.
Sure.
So I do have one spoiler alert, is that we hewed pretty closely to the model law. So I know this will be kind of, some of this can be a little dry, but I would say there's not going to be too many surprises. We're pretty in line with what's in the model law. That's the only other thing I had to add at this time.
And Scott and Jason, just yeah, good afternoon. This is Tim Mullen with the NEIC. So I think I was a little tardy getting on as well. So sorry about that.
Sorry about that. Having a little bit of technical difficulties on my end. Did we lose Scott?
We may have.
Okay, I'll just give him a moment. Yeah, I know.
No, they haven't done stickers for licenses in years.
So, Karen, do we need somebody to just start reading this for people, or I mean, I could probably start
Sure.
doing that while we wait for
Go
Scott to
ahead.
find his way back in.
Yeah,
All right.
go ahead, Jason.
So, and you all have to bear with me. This is my first one of these I've been through, so I'll try not to butcher things too badly. I'm not 100% sure what I'm doing. So, anyway. Okay, so we'll start with, you should all be able to see on the screen there, the public adjuster rulemaking draft. Purpose and scope, the rule governs the qualifications and procedures for the licensing of public adjusters. It specifies the duties of and restrictions on public adjusters, which include limiting their licensure to assisting insureds in first-party claims, excluding claims for personal or commercial auto lines of insurance. So, the public adjuster, this is defined as meaning any person who, for compensation or any other thing of value on behalf of the insured, acts or aids solely in relation to first-party claims arising under insurance contracts that insure the real or personal property of the insured on behalf of an insured in negotiating for or affecting the settlement of a claim for loss or damage covered by an insurance contract. B, advertises for employment as a public adjuster of insurance claims or solicits business or represents himself or herself to the public as a public adjuster or first-party insurance claims or losses or damage arising out of policies or insurance that insure real or personal property. Or C, directly or indirectly solicits business, investigates or adjusts losses, or advises an insured about first-party claims for losses or damages arising out of policies of insurance that insure real or personal property for another person engaged in the business of adjusting losses or damages covered by an insurance policy for the insured.
All right, so let's stop there, Jason. We've got Scott back on. And so Scott, Jason read through section 1 and section 2. Oh, you're on mute.
Sorry, I'm on my phone now, so can you see me okay?
Yes, we can see you.
And pinch hitting for me there. So with that, let's before we delve into section 3, does anyone have any questions, comments, or concerns with sections 1 or 2?
Nope.
Very good. Okay, Jason, could you continue on, please?
Sure. Okay, section 3. A person shall not act, hold himself, herself out as a public adjuster solicit or negotiate a contract for public adjusting services in this state unless the person is licensed as a public adjuster in accordance with this rule. Section B, a person licensed as a public adjuster shall not misrepresent to a claimant that he or she is an adjuster representing an insurer in any capacity, including acting as an employee of the insurer or acting as an independent adjuster, unless so appointed by an insurer in writing to act on the insurer's behalf for that specific claim or purpose. A licensed public adjuster is prohibited from charging that specific claimant a fee when appointed by the insurer and the appointment is accepted by the public adjuster. C, a business entity acting as a public adjuster is required to obtain a public adjuster license. Application shall be made using the Uniform Business Entity application. Before approving the application, the insurance commissioner shall find that 1, the business entity has paid the fees set forth in OAR 836-009-0007 and the business entity has designated a licensed public adjuster responsible for the business entity's compliance with insurance laws, rules, and regulations in this state. Section D. Notwithstanding subsection A through C, a license as a public adjuster shall not be required of the following. Number 1, an attorney at law admitted to practice in this state when acting in his or her professional capacity as an attorney. 2, a person who negotiates with or settles claims arising under a life or health insurance policy or an annuity contract. 3, a person employed only for the purpose of obtaining facts surrounding a loss or furnishing technical assistance to a licensed public adjuster, including photographers, estimators, private investigators, engineers, and handwriting experts. 4, a licensed healthcare provider or employee of a licensed healthcare provider who prepares or files a health claim form on behalf of a patient, or Section 5, a person who settles subrogation claims between insurers.
Thank you. Any commentary on Section 3?
Scott, the only this is Tim Mullen at the NEIC, and I don't know if you or Jason were on the call of the producer licensing task force. I just would note some of the language in that subsection A is still being discussed at the NEIC, but it's that solicit or negotiate a contract for public adjusters services. I haven't received any additional comments on that, so I assume it'll go through the NEIC fine, but just thought I'd note that if that's of relevance for your discussions.
Yes, thank you, Tim. Any other commentary? Hearing none. Jason, why don't you take us through 4, 5, 6, and 7? I'm still trying to get access to my documents here.
No worries. Okay, Section 4, application for a license. A person applying for a public adjuster license shall make an application to the commissioner as outlined in ORS 744.518, OAR 836-071-0101, OAR 836-071-0105, OAR 836-071-0110, and OAR 836-71-0118. Resident adjuster qualification rules. Before issuing a public adjuster license to an applicant under this section, the commissioner shall find that the applicant satisfies the requirements set forth under ORS 744.525. Non-resident adjuster qualification rules. Before issuing a public adjuster license to an applicant under this section, the commissioner shall find that the applicant satisfies the requirements under ORS 744.528. Section 7 regards the examination. An individual applying for a public adjuster license under this rule shall pass a written examination in accordance with OAR 836-071-0120 and OAR 836-071-0127. Section 8, exemptions from examination. An individual who applies for a public adjuster license in this state who was previously licensed as a public adjuster in another state based on a public adjuster examination shall not be required to complete any pre-licensing examination. This exemption is only available if the person is currently licensed in that state or if the application is received within 12 months of cancellation of the applicant's previous license, and if the prior state issues a certification that at the time of cancellation, the applicant was in good standing in that state, or the state's producer database records or records maintained by the NAIC, its affiliates, or subsidiaries indicate that the public adjuster is or was licensed in good standing. A person licensed as a public adjuster in another state based on a public adjuster examination who moves to this state shall make application within 90 days of establishing legal residence to become a resident licensee pursuant to Section 5. No pre-licensing examination shall be required of that person to obtain a public adjuster license. Section C. An individual who applies for a public adjuster license in this state who was previously licensed as a public adjuster in this state shall not be required to complete any pre-licensing examination. This exemption is only available if the application is received within 12 months of the cancellation of the applicant's previous license in this state, and if at the time of cancellation the applicant was in good standing in this state.
Yeah, let's go. Thank you, Jason. Let's cut it off there and see if we have any comments, questions, or concerns in sections 4 through 8. Okay, moving on to section 9. Jason, would you mind?
Jason? Jason, you're on mute.
Thank you.
Thank you. So section 9 is non-resident license reciprocity. Unless denied licensure pursuant to section 11, a non-resident person shall receive a non-resident public adjuster license if the person is currently licensed as a resident public adjuster in good standing in his or her home state. 2, the person has submitted the proper request for licensure and has paid the fees required by OAR 836-009-0007. 3, the person has submitted or transmitted to the commissioner the appropriate completed application for licensure, and the person's home state awards non-resident public adjuster licenses to residents of this state on the same basis. Section B, the commissioner may verify the public adjuster's licensing status through the producer database maintained by the NAIC, its affiliates, or subsidiaries. Section C, as a condition to the continuation of a public adjuster license issued under this section, the licensee shall maintain a resident public adjuster license in his or her home state. The non-resident public adjuster license issued under this section shall terminate and be surrendered immediately to the commissioner if the home state public adjuster license terminates for any reason, unless the public adjuster has been issued a license as a resident public adjuster in his or her new home state. Notification to the state or states where non-resident license is issued must be made as soon as possible, yet no later than 30 days of change in new state resident license. Licensee shall include new and old address. A new state resident license is required for non-resident licenses to remain valid. The new state resident license must have reciprocity with the licensing non-resident state for the non-resident license not to terminate.
Thank you, Jason. Comment concerning section 9. Okay, hearing none. I think I'm back on, Jason, if you want me to relieve you from the reading portion.
Whatever works for you.
Okay, let me pull up some more stuff and I'll let you go through 10 as well.
Okay. So, section 10 regarding licenses. Unless denied licensure under this rule, persons who have met the requirements of this rule shall be issued a public adjuster license. A public adjuster license shall remain in effect unless revoked, terminated, or suspended as long as the request for renewal and fee set forth in OAR 836-071-0130 and OAR 836-009-0007 is paid and any other requirements for license renewal are met by the due date. The licensee shall inform the commissioner by any means acceptable to the commissioner of a change of address, change of legal name, or change of information submitted on the application within 30 days of the change. D. A licensed public adjuster shall be subject to ORS 746.230 and ORS 746.240. E. A public adjuster who allows his or her license to lapse may, within 12 months from the due date of the renewal, be issued a new public adjuster license upon the commissioner's receipt of the request for renewal. However, a penalty in the amount of double the unpaid renewal fee shall be required for the issue of the new public adjuster license. The new public adjuster license shall be effective the date the commissioner receives the request for renewal and the late payment penalty. F. Any public adjuster license that fails to apply for renewal of a license before expiration of the current license shall pay a lapsed license fee of twice the license fee and be subject to other penalties as provided by law before the license will be renewed. If the Department of Consumer and Business Services receives the request for reinstatement and the required lapsed license fee within 365 days of the date of the license lapse, the department shall reinstate the license retroactively to the date the license lapsed. If the person applies for reinstatement more than 365 days from the date of lapse, the person shall reapply for the license under this rule. G. A licensed public adjuster that is unable to comply with license renewal procedures due to military service, a long-term medical disability, or some other extenuating circumstance may request a waiver of those procedures. The public adjuster may also request a waiver of any examination requirement, fine, or other sanction imposed for failure to comply with renewal procedures.
Thank you, Jason. Comments on section 10? Aaron, I can't really see the raise hand function on my phone, so if there is some, could you alert me to that? Right, then moving on to section 11, license denial, non-renewal, or revocation. The commissioner may place on probation, suspend, revoke, or refuse to issue or renew a public adjuster's license in accordance with ORS 744-.584. Continuing education. An individual who holds a public adjuster license shall satisfactorily complete the continuing ed requirements as provided by ORS 744.521-2AB. Public adjuster fees, section 13. A public adjuster shall not pay a commission, service fee, or other valuable consideration to a person for investigating or settling claims in the state if that person is required to be licensed under this rule and is not so licensed. A person shall not accept a commission, service fee, or other valuable consideration for investigating or settling claims in the state if that person is required to be licensed under this rule and is not so licensed. A public adjuster may pay or assign a commission, fees, or other valuable consideration to persons who do not investigate or settle claims in the state unless the payment would violate ORS 746.045. No public adjuster shall charge, agree to accept as compensation or reimbursement any payment, commission, fee, or other thing of value more than 10% for any catastrophic insurance claim settlement and no more than 15% for any insurance claim settlement. No public adjuster shall require, demand, or accept any fee, retainer, compensation, deposit, or other thing of value prior to the settlement of a claim.
And we have a hand raised from Jeffrey.
Thank you. I represent the National Association of Public Insurance Adjusters, and we tend to handle the more larger and complex and tend to be commercial claims throughout the industry. We are okay with the fee caps. We obviously would like there to be no fee cap, but we are okay with the 15 and 10 that is presented in this draft. However, I want to let you know that there are other public adjusting agencies, several of them, that will have an objection to this and will fight this once this becomes available to the public. We were just on a call, and I say we because Tim Mullen was there as well, in which several public adjuster agencies that handle smaller residential type claims did object to this. And I have no doubt they will object to this in Oregon as well. 18 of the 50 states have fee caps right now, so it is the minority. And the argument is that when the fee cap is in place, people that have smaller claims, say under $25,000, are unable to get representation because there is no ability for a public adjuster to take that claim and make any money. So it hurts the person with the small claim.
Thank you, Jeff. Very good feedback.
Yeah, and just to kind of follow up Jeffrey's comments, yeah. So that this is a topic, the percentage of fee caps. If you haven't been on some of the recent calls of the NAIC, this is still ongoing discussions, and Jeffrey did a very good job summarizing kind of the positions and what's been discussed. Yeah.
I'm sorry, I'm just taking notes here real quick. Great feedback. Thank you. Any other commentary on those last two sections? Okay, moving on to section 14. It involves a contract between public adjuster and the insured. Public adjusters shall ensure that all contracts for their services are in writing and contain the following terms: legible full name of the adjuster signing the contract as specified in the DCBS service records, permanent home state, business address, and phone number. Department of Consumer Business Services, the title of public adjuster contract, the insured's full name, street address, insurance company name, and policy number. A description of the loss and its location, if applicable. Description of the services to be provided to the insured. Signatures of the public adjuster and the insured. The date the contract was signed by the public adjuster and the date the contract was signed by the insured. At its station language stating the public adjuster is fully bonded pursuant to state law, and full salary, fee, commission, compensation, or other consideration the public adjuster is to receive for services. The contract may specify that the public adjuster shall be named as a co-payee on insured's payment of a claim. Part 1, if the compensation is based on a share of the insurance settlement, the exact percentage shall be specified. 2, initial expenses to be reimbursed to the public adjuster from the proceeds of the claim payment shall be specified by type, with dollar estimates set forth in the contract and with any additional expenses first approved by the insured. Part 3, compensation provisions in a public adjuster contract shall not be redacted in any copy of the contract provided to the commissioner. Part C, if the insurer, not later than 72 hours after the date on which the loss is reported to the insurer, either pays or commits in writing to pay to the insured the policy limit of the insurance policy, the public adjuster shall, 1, not receive a commission consisting of a percentage of the total amount paid by an insurer to resolve the claim. 2, inform the insured that loss recovery amount might not be increased by the insurer. And 3, be entitled to only a reasonable compensation from the insured for services provided by the public adjuster on behalf of the insured, based on the time spent on a claim and the expenses incurred by the public adjuster until the claim is paid or the insured receives written commitment to pay from the insurer.
Oh, goodness.
Part D, a public adjuster shall provide the insured a written disclosure concerning any direct or indirect financial interest that the public adjuster has with any other party who is involved with any aspect of the claim other than the salary, fee, commission, or other consideration established in the written contract with the insured, including but not limited to any ownership of, other than a minority stockholder, or any compensation expected to be received from any construction firm, salvage firm, building appraisal firm, motor vehicle repair shop, or any other firm which provides estimates for work that or performs any work in conjunction with damages caused by the insured loss on which the public adjuster is engaged. The word firm shall include any corporation, partnership, association, joint stock company, or person. Part E, a public adjuster contract may not contain any contract term that allows the public adjuster's percentage fee to be collected when money is due from an insurance company but not paid, or that allows a public adjuster to collect the entire fee from the first check issued by the company rather than as a percentage of each check issued by an insurance company. Item 2 requires the insured to authorize an insurance company to issue a check only in the name of the public adjuster. 3, imposes collection costs or late fees. Or 4, precludes a public adjuster from pursuing civil remedies. Part F, prior to signing of the contract, the public adjuster shall provide the insured with a separate disclosure document regarding the claim process that states property insurance policies obligate the insured to present a claim to his or her insurance company for consideration. There are 3 types of adjusters that could be involved in the process. The definition of the 3 types are as follows. Part A, a company adjuster means insurance adjusters who are employees of an insurance company. They represent the interest of the insurance company and are paid by the insurance company. They will not charge you a fee. B, independent adjuster means the insurance adjusters who are hired on a contract basis by an insurance company to represent the insurance company's interest in the settlement of the claim. They are paid by your insurance company. They will not charge you a fee. C, public adjuster means the insurance adjusters who do not work for any insurance company. They work for the insured to assist in the preparation, presentation, and settlement of the claim. The insured hires them by signing a contract agreeing to pay them a fee or commission based on the percentage of the settlement or other method of compensation. Part 2, the insured is not required to hire a public adjuster to help the insured meet his or her obligations under the policy, but has the right to do so. 3, the insured has the right to initiate direct communications with the insured's attorney, the insurer's adjuster, and the insurer's attorney or other person regarding the settlement of the insured's claim. 4, the public adjuster is not a representative or employer of the insurer. 5, the salary, fee, commission, or other consideration is the obligation of the insured, not the insurer.
Hey, Scott.
Yeah.
Let's go ahead and take a question from Jeff right now. I don't know how much longer or how long this section is yet.
Thank you.
Go ahead, Jeffrey.
Scott probably needs a break anyway. 2 comments.
Yeah, thanks.
2 comments so far on this section. A10 says that the public adjuster's contract should have attestation language stating the public adjuster is fully bonded pursuant to state law. There is nothing in this draft that requires the public adjuster to have a bond. If it were to be added, if the intent is for a public adjuster to have a bond, it would be section 12 of the NAIC Model Act. But that has not been included here. So we either have to include the requirement for a bond, or get rid of A10?
And Jason
And I
has
have
his
one more.
hand up. Oh, okay. I'm sorry. Go ahead, Jeff.
I'm sorry. In paragraph D, requires written disclosure between the public adjuster and any other company involved in the claim that the public adjuster may have an ownership interest in. It is the opinion of the National Association of Public Insurance Adjusters that this should never happen, even if disclosed, and that a public adjuster should never also be the contractor on a claim or have an ownership interest in the contracting company on the same claim that they are a public adjuster. We believe that is a conflict of interest.
And that was section 14, part D, correct?
Part D, correct.
Thank you. Karen, did you say Jason had his hand?
Yes.
Yes, I was just going to comment as far as the language regarding the bond. Currently, we don't have any bond requirements for adjusters, and our intention, I believe, is to maintain that for public adjusters as well. We don't require them for independent adjusters, and I don't believe there's, or at least if there's an intention to require a bond for public adjusters, I'm not aware of it. I think this was something that got copied over from an earlier draft of the model law and may not necessarily, that may be open to change.
Great, thank you. Great feedback. Any other comments? Okay, let's continue on with section F. Prior to the signing of the contract, the public adjuster shall provide the insured with a separate disclosure regarding the claim that states, 1, property insurance policies obligate the insured to present a claim to his or her insurance company for consideration. Whoops, I think I went through that already, didn't I?
Yes, you already read F.
Okay.
Yeah, I think we're on section G.
Okay, thank you. Part G, the contracts shall be executed in duplicate to provide an original contract to the public adjuster and an original contract to the insured. The public adjuster's original contract shall be available at all times for inspection without notice by the commissioner. H, the public adjuster shall provide the insured a notification letter which has been signed by the insured authorizing the public adjuster to represent the insured's interest. The insurer shall verify the public adjuster holds a valid license with the Department of Consumer and Business Services. I, the insured has the right to rescind the contract within 3 business days after the date the contract was signed. The rescission shall be in writing and shall be mailed or delivered to the public adjuster at the address in the contract within 3 business day period. J, if the insured exercises the right to rescind the contract, anything of value given by the insured under the contract will be returned to the insured within 15 business days following the receipt by the public adjuster of the cancellation notice. Part K, subject to its terms relating to assignability, a property insurance policy, whether heretofore or hereafter issued, under the terms of which the policy and its rights and benefits are assignable, may provide that the rights and benefits under the insurance may only be assigned to a person who has legal authority to represent the name insured or to a subsequent owner of the property to whom title is transferred. It may explicitly prohibit assignment of rights and benefits to any other person, including a property repair contractor. For the purposes of this subsection, having legal authority to represent the insured includes the person named by the named insured as having the named insured's power of attorney, the person who is the named insured's licensed public adjuster, or any other comparable person. Property repair contractors operating in the state may not subvert the public adjuster licensing requirements of this rule through the acquisition of a power of attorney from the named insured.
And we have Jeff's hand raised.
Thank you again. I apologize for so many comments. I'd like to comment on paragraph H, specifically the part where it says the insurer shall verify the public adjuster holds a valid license with the Department of Consumer and Business Services. The intent of this, my understanding and participating with all the NAIC calls, and I believe this was something that may have actually been suggested by NAPIA. It's not just for insurance companies to verify that public adjusters are licensed. It's to verify that anyone acting as a public adjuster is licensed. So if there's a contractor on the claim and they are performing the services that require a license, such as negotiation or policy interpretation, the insurance company should verify that person has a public adjuster's license. A good example of how we would like to see the rule written is Rhode Island has language that I certainly can forward, but it says anyone acting as a public adjuster, the insurance company needs to verify that they are in fact licensed. The policyholders don't realize that contractors cannot negotiate or get involved with coverages. And the point of this is to make sure that the only person in the claims process that can possibly enforce this is the insurance company.
Thank you, Jeffrey, and please don't apologize for giving input. That's why we're here. Thank you.
And Tim has his hand up.
Yeah, and yeah, I just want to just quickly note as you go through these provisions again, if you haven't been on the most recent producer licensing task force calls, the last sentence of H, which Jeff had mentioned, that's still in draft form at the NAIC as well as subsection K in your draft. But again, I anticipate those being adopted by the NAIC, but just wanted to make sure you noted that as you go through. They're not part of the adopted NAIC model at this point.
Thank you. Okay, moving on to section 15. Licensee's place of business. A public adjuster shall maintain a place of business and all of the usual and customary records in accordance with ORS 744.578. Section 16, escrow or trust accounts. A public adjuster who receives, accepts, or holds any funds on behalf of the insured towards the settlement of a claim for loss or damage shall deposit the funds in a non-interest bearing escrow or trust account in a financial institution that is insured by an agency of the federal government in the public adjuster's home state or where the loss occurred. Any comments concerning section 16? Okay, moving on to section 17, record retention. Part A, a public adjuster shall maintain a complete record of each transaction as a public adjuster. The records required by this section shall include the following. 1, name of the insured. 2, date, location, and amount of loss. 3, copy of the contract between the public adjuster and the insured. 4, name of the insurer, amount, expiration date, and number of each policy carried with respect to the loss. 5, itemized statement of the interest of the insured's recoveries. Item 6, itemized statement of all compensation received by the public adjuster from any source whatsoever in connection with the loss. Item 7, a register of all monies received, deposited, dispersed, or withdrawn in connection with a transaction with an insured, including fee transfers and disbursements from a trust account and all transactions concerning all interest-bearing accounts. Number 8, the name of the public adjuster who executed the contract. Number 9, name of the attorney representing the insured, if applicable, and the name of the claims representative of the insurance company. And 10, evidence of financial responsibility in a format prescribed by the insurance commissioner. Part B, records shall be maintained for at least 5 years after the termination of the transaction with an insured and shall be open to examination by the commissioner at all times. Then Part C, records submitted to the commissioner in accordance with this section shall contain information identified in writing as proprietary by the public adjuster shall be treated as confidential by the commissioner. Any questions or comments concerning section 17? Okay, moving on to section 18, standard of conduct of public adjuster. Part A, a public adjuster is obligated under his or her license to serve with objectivity and complete loyalty to the interest of his client alone and to render to the insured such information, counsel, and service as within the knowledge, understanding, and opinion in good faith of the licensee as will best serve the insured's insurance claim needs and interests. B, a public adjuster shall not solicit or attempt to solicit an insured during the progress of a loss producing occurrence as defined in the insured's insurance contract. C, a public adjuster shall not advertise or infer damage unless an inspection of the property has been completed. Part D, a public adjuster shall not offer to pay an insured's deductible or claim the insured's deductible will be waived as an inducement to using the services of a public adjuster. Part E, a public adjuster shall not permit an unlicensed employee or representative of the public adjuster to conduct business for which a license is required under this rule. A public adjuster shall not, Part F, a public adjuster shall not have a direct or indirect financial interest in any aspect of the claim other than the salary, fee, commission, or other consideration established in the written contract with the insured. Part G, a public adjuster shall not require any interest in salvage of property subject to the contract with the insured unless the public adjuster obtains written permission from the insured after settlement of the claim with the insurer. The public adjuster shall abstain from referring or directing the insured to get needed repairs or services in connection with a loss from any person, 1, with whom the public adjuster has a financial interest, or 2, from whom the public adjuster may receive direct or indirect compensation for the referral. Part I, any compensation or anything of value in connection with the insured specific loss that will be received by a public adjuster shall be disclosed by the public adjuster to the insured in writing, including the source and amount of any such compensation. Part J, public adjusters shall adhere to the following general ethical requirements. Number 1, a public adjuster shall not undertake the adjustment of any claim if the public adjuster is not competent and knowledgeable as to the terms and conditions of the insurance coverage or otherwise exceeds the public adjuster's current expertise. Number 2, a public adjuster shall not knowingly make any oral or written material misrepresentations or statements which are false or maliciously critical and intended to injure any person engaged in the business of insurance to any insured client or potential insured client. Number 3, no public adjuster, while so licensed by the DCBS, may represent or act as a company adjuster or an independent adjuster on the same claim. Number 4, the contract shall not be construed to prevent an insured from pursuing any civil remedy after the 3 business day revocation or cancellation period. Then number 5, a public adjuster shall not enter into a contract or accept a power of attorney that vests in the public adjuster the effective authority to choose the persons who shall perform the repair work. And 6, a public adjuster shall ensure that all contracts for the public adjuster services are in writing and set forth all terms and conditions of the engagement.
And Jeff has his hand up.
Go ahead, Jeff.
I have 2 comments. Section 18F. A public adjuster shall not have a direct or indirect financial interest in any aspect of the claim contradicts 14D. 14D says you can have a financial interest if you disclose it, and 18F says you can't have a financial interest at all. So they contradict each other. We prefer to keep 18F, which says you cannot have a financial interest in any other aspect of the claim whatsoever. Secondly, in 18J3, no public adjuster may act as a company adjuster or independent adjuster on the same claim. We don't believe that if you're a public adjuster, we don't believe you should even be licensed as an independent adjuster. And an example is if you're representing a homeowner and they're insured with a company that you get a lot of business from as an independent adjuster, that presents a real big conflict of interest. So we think if you're a public adjuster, you're only a public adjuster.
I know that is a point of contention with a number of parties. Does anyone from NAIC or NIPR have any insight as to how discussions were with the model development concerning that issue?
Yeah, I will say that one of the primary concerns raised when the discussions began at the NEIC was addressing potential conflicts of interest. So that is a priority issue being discussed.
And Tim, this is Lori Wolf as well. I would just add that I was around when this model was being adopted as a former regulator, and the conflict of interest issue was a concern to many states. There are states that do prohibit it, but not all.
Mm-hmm. Yeah, and so I'm trying to find the language again. So yeah, the current language, at the NEIC is to essentially prohibit any direct or indirect financial interest, and kind of move away from even if there's disclosure, right? So.
Okay.
Yeah, I would simply add that if they don't have the specific conflict of interest on a given transaction, what happens is they'll have prohibitions where you cannot concurrently hold both. So again, there's the little differences here depending upon the state. But this was clearly an issue raised back when the Public Adjuster Model Act was being drafted, which is a long time ago. The original model was adopted. I've been on NAPR side now for 17 years, so it was prior to me coming over, maybe 2006. Tim?
Mm-hmm. Yeah. And then the other piece I would just mention the subpoints C and D. While I think those will be adopted by the NAIC, those are still part of the draft of the NAIC model being discussed.
Is that section 18 C and D?
Yes, yeah. And what I've heard, right, is that states have seen issues where public adjusters, I think they've seen issues where they're acting as a contractor, or they have some type of financial interest in a contracting company and acting as a public adjuster on the same on the same claim.
And the National Association of Public Adjusters is against that. In fact, we our bylaws don't even allow you to be a member if you have an interest in a contracting company.
Yeah.
We believe it's a conflict of interest that can only harm the policyholder.
Right.
And Tim, I would just say again, that was an issue that was brought up during the concern of the development from the model from the other states. So that is consistent, and obviously it's still subject to the provisions being discussed today.
Great, thank you. Very good input. Okay, bringing this thing home, I think we left off on item K. A public adjuster may not agree to any loss settlement without the insured's knowledge and consent. Section 19, notices required. The public adjuster shall report to the commissioner any of the conditions specified in ORS 744.581. Any other comments, concerns, questions that you have thought of since we went through the section that you may have questions on?
This is Jeff again. I have one more.
Yes, sir. Go ahead.
Just wondering why section 16 of the model bill titled unlicensed actors was omitted. This section makes it a fraudulent insurance act if somebody represents or advertises themselves to be a public adjuster who has not met the requirements of licensure or conducts business for which a license is required under this act without a license. If you're going to prohibit it, it has to be a crime. It has to be illegal. There has to be consequences.
And you said that was section 15 in the model?
Section 16 of the model titled unlicensed actors.
Yeah, and that's the new section of the NAIC model being proposed, and what regulators have commented is that sometimes it's hard, right, if somebody's unlicensed to get some regulatory, oversight of them. So that's where that section came from, under the NAIC model.
Okay, thank you. Thank you for pointing that out. Either I missed that or it came in a different draft after the one we were working off of.
Right, that's what I was going to add. I would imagine that section probably was added. This initial document and a lot of these things, I think I did this work several months ago, so that there are new revisions to the Public Adjuster Model Act that I may not have been privy to, and I haven't updated the document since then. So that's probably the reason for that.
Great. So we will certainly look into that. Thank you. Okay, let's see, Karen, why don't we pivot now to the notice of rulemaking statement of need and fiscal impact. And maybe you could scroll down to the second page. We've already gone through kind of the background of the rule itself.
Okay. And my system is slow. Second page, I'm sorry. Okay.
Yes, right.
Here we go. Okay.
Statement identifying how adoption of the rules will affect equity in the state. Who is this going to impact, and how might it impact one group of people differently than the other? This rulemaking will impact public adjusters operating in Oregon. This rule is not anticipated to have any disparate impact on any particular demographic of consumers. Anyone have any questions or comments or additions to that statement? Hearing none, moving on to the next portion, fiscal and economic impact. Based on the information available to the DCBS, briefly discuss the cost of compliance for business. State whether there are compliance costs for small businesses, independently owned and operated with fewer than 50 employees. Fees required by this rule are the same as the fees currently incurred by public adjusters that are being licensed as a general adjuster in Oregon. There is no change in fees based on one type or the other. The costs incurred to the DFR should theoretically decrease, as this rulemaking will avert the need for manual paper application and processing. Does anyone have any other thoughts on that section? The next section is cost of compliance for small businesses. State agencies impacted include the DFR licensing team. Adoption of this rule will eliminate manual application processing and instead enable the team to process using NEISBS and NIPR. Economic impact to the public adjuster group is negligible. The application, exam, and licensing fees will be the same as they are today. Applicants will be able to apply online instead of utilizing a manual paper application. Item 2A, estimate the number and type of small businesses subject to the rules. Currently, the DFR does not have a specific licensor for public adjusters, so we have no data on the number and type of public adjusters operating in Oregon. 2B, describe the expected reporting, record keeping, and administrative activities and costs required to comply with the rules. Reporting, record keeping, and administrative costs will remain unchanged with the adoption of this rule. Record keeping will be more accurate moving forward as public adjusters will be tracked independently from independent adjusters. 2C, estimate the costs of professional services, equipment, supplies, labor, or increased administration required to comply with this rule. I've noted no increase in costs are anticipated. How were small businesses involved in the development of this rule? The Rulemaking Advisory Committee includes representation from the NIPIA to represent the perspective of the public adjusters, which include both large and small businesses. Confirming today is the first RAC meeting. The parties invited to the RAC represent the interests of those most likely affected by this rule, including trade organizations, consumer advocacy, carriers, and the National Association of Public Insurance Adjusters. The proposed rule is not expected to have any particular impact on any particular community in Oregon. Any comments or questions or concerns that information is not accurately represented?
Yeah, Scott, this is Tim, and this is not my argument or position. So this is informational that I'm passing on. On the fee cap issue, the American Association of Public Adjusters said that on our call, on the NAIC call, that putting a fee cap might negatively impact individuals, perhaps of lower income or individuals who may not be proficient in English, because those lower value claims will not have representation of a public adjuster because of those fee caps. So I just kind of pass that on. It's not the NAIC's position. It's not my position, but wanted to at least pass that comment that I heard on the call earlier today. And Jeff, I don't know if you were on the call, but you may have other thoughts on that as well.
I was on the call, and as I said earlier today, the fee cap hurts the people with smaller claims because public adjusters don't want to take claims where they can only make $500 or $1,000 because it actually costs us more than that to handle a claim. And you'd be amazed, sometimes the small claims take just as many hours of work as the big claims. So while NAPIA handles mostly larger claims where it's not an issue, I do completely agree with the argument that APIA and other smaller public adjusting associations have presented.
Great input. Thank you. We will certainly take that into consideration. Okay, any other commentary on the statement of need and fiscal impact? Hearing none. Karen, can you pivot over back to the agenda? So we'll wrap this up. Actually, looks like we'll get you out of here in time. The next steps, if you have additional thoughts after this meeting or would like to clarify further any commentary you made during this meeting, I would encourage you and invite you to document those in writing and send your written input to me. The DFR will take all of this commentary and revisit these two documents to see what changes might need to be necessary. If you could submit your comments to us by November 15th, that would be fantastic. The next RAC meeting is scheduled for December 5th from 10:30 till noon. Very good. Anything for the good of the order?
Yes. We do need to open up for public comment. I know that members of the RAC committee commented throughout the discussion, but are there any folks on the line that are from the public? This is your opportunity to bring up any concerns or issues. All right. We have addressed or taken care of that item.
Okay, very good. Again, I appreciate everyone's involvement. I'm hopeful you'll be able to join us again on December 5th for a follow-up RAC meeting. And again, if you have any additional comments you'd like to share, please send them in writing to me and Karen. We'll be sure to get that and circle the wagons here at the DFR to take another run at this. With that, I'll give you a few minutes back to your day. And again, I thank you for your participation. Have a great day.
Thank you, everyone.
Thank you.
Thank you.